Aloe Yoga and 15 of its influencers are being sued in a $150 million false advertising class action lawsuit. In this video, we're going to get into the world of influencer marketing regulations using the recent Aloe lawsuit as our case study. So if you're a creator that does sponsored content or you're a brand that works with influencers, you can't afford to miss this information. In the lawsuit, Aloe and the influencers are being sued for allegedly hiding paid sponsorships on social media. The plaintiffs say that they paid more than they would have for those Aloe products because they believed they were getting genuine recommendations when really they were being served ads. In the next few minutes, I'm going to break down the rules around influencer marketing, why both brands and creators should care about compliance, and take a look at what Aloe allegedly did wrong here. So let's get into it. First, let's understand what the Federal Trade Commission actually requires. The key principle is simple: transparency. Consumers have a right to know when content that they view has been influenced by some brand relationship. The FTC requires disclosure of any material connection between an influencer and a brand. So what is a material connection? Well, it's any relationship between an influencer and a brand that would affect the weight or the credibility that the audience would give to an endorsement. So that can include obvious things like getting paid to create a post, and other things like getting free product or a discount in exchange for a post, or even things like a family or an employment relationship. If that material connection is not otherwise obvious to the audience, then the FTC says it has to be disclosed. So when do you have to make a disclosure? Well, anytime you mention or tag a brand or even show off a product from a brand that you have a material connection with, you need to disclose that relationship. And that's true even if you authentically love the brand, or even if they didn't expressly ask you to make a post. If you've been receiving free product from a brand and you decide to make a post about it, the Federal Trade Commission would tell you that you have to disclose that relationship when you post that content. So how should you make those disclosures? It's not enough to just have the disclosures. The FTC says you need to make them clear and conspicuous. And what that basically means is the disclosure should be unavoidable to a reasonable person viewing that content. So for example, if you're disclosing your relationship through something like #ad in the caption of a post, you shouldn't have that hashtag in the middle of a sea of other hashtags where it would be easy to miss it. Or you shouldn't have the disclosure below the fold in the caption of a post so that people have to expand it in order to see it. Basically, make the disclosure hard to miss if you have to make one. So why should brands and creators care about these disclosure rules? Well, aside from basic ideas like your audience should know when they're being advertised to, there are legal penalties for noncompliance. The FTC can impose a civil penalty of around $52,000 per violation, which can mean per undisclosed post. And if you're running a big influencer campaign, that number can get pretty big pretty quickly. It's also important to understand liability for non-disclosure violations is shared by both the brand and the influencer, and potentially any advertising agency that was involved in creating and disseminating the content. So it's a mistake to think that if I, a creator, fail to make a disclosure in one of my posts, that it's really the brand's problem. There's no reason for me to get in trouble legally. That's not the case, and the FTC is very clear about that. It's also a mistake to think that it's just the FTC that you potentially need to worry about. While it's historically been the case that these rules are enforced by the FTC, as we're seeing with this Aloe Yoga case and several others, consumers can bring class action lawsuits for violations of state consumer protection law. Basically, the idea is because you violated the FTC's rules, you've also violated these state laws that allow consumers, like members of your audience, to bring lawsuits against you. Now let's look at the Aloe Yoga case in particular. For some context, this is not the only class action that's currently pending against brands and individual influencers for not making disclosures in social media posts. The same law firm is currently bringing cases against Revolve, High-Tech Pharmaceuticals, Celsius Beverages, and a few others, essentially all alleging the same thing. Here, the consumers allege that Aloe and the influencers engaged in a coordinated plan to hide the sponsored nature of the content that they were posting. The complaint alleges that Aloe and the influencers deliberately avoided using Instagram's built-in ad disclosure feature because they were concerned that using it would hurt the reach of the posts. By skipping proper disclosures, they allegedly maintained higher reach and got better engagement while creating the false impression that these posts were just genuine recommendations instead of advertisements. The case is brought on behalf of everyone in the United States who purchased Aloe Yoga products. The effect of that is that each of these individual influencers faces $150 million in potential liability for something as seemingly simple as not disclosing that certain content was sponsored by Aloe. So what are some of the takeaways from cases like this? If you're an influencer or a creator, it's important to understand what your disclosure obligations are and follow them. If you're working with a brand that specifically asks you not to make a disclosure, which I have seen from time to time, you should treat that as a dark red flag and consider not working with the brand. It's just not going to be worth it from a legal perspective or potentially from your reputation. So if you're getting paid or you're getting free product or you're getting a discount from a brand, understand that you need to tell your audience about that relationship when you make a post.
Huge thanks to Sweetwater for sponsoring this video. Sweetwater was kind enough to provide me with these faux cow Shape 65, and they also sent me this PreSonus Faderport 16 that you see sitting right in front of me.
You don't necessarily have to use a hashtag. Like, hashtag ad is not the only way to make a compliant disclosure. You can just say ad in the caption, or you can just say sponsored, or the brand name and then the word partner. As long as it's clear to the audience that you have a relationship with the brand that you're promoting and you're disclosing it in a way that's clear and conspicuous, generally speaking, you're covered. And if you're a brand that's working with creators, one thing that's really important to have is some agreement in writing with everyone that you work with. And in that agreement, you should make it clear to the creator that they have this obligation to make a disclosure when they post sponsored content. The FTC also requires that you educate your creators and your influencers about their disclosure requirements and that you're monitoring their post for compliance. That doesn't mean that if you're running a huge influencer campaign that you need to analyze every single post that goes live, although that's not really a bad idea to get approval beforehand. But what it does mean is you should at least be spot checking content that's out there to make sure that people are complying with those requirements. And if they're not, then you should have it in your agreement that you have the right to either demand that they take down the content or fix it to make the disclosure or something like that so that you can take action in case something bad happens. The bottom line is that both parties share responsibility for making disclosures. The brand can't just pass the buck to the influencers, and influencers can't just claim ignorance of the law. The Aloe case makes clear that the stakes for compliance have never been higher. It's no longer just the FTC that you need to worry about. A few years ago, in an interview with Vox, I predicted that we would see crafty plaintiffs' lawyers try to make claims about these non-disclosure rules that could proceed as a class action. It would only take one case to get a favorable ruling in a federal court for many other similar cases to follow. And that's exactly what happened here. These lawyers got a favorable ruling early in a different case that was filed in Illinois over the same thing, and since then they've filed about half a dozen of these, including the Aloe Yoga case. With potential FTC penalties exceeding $50,000 per post and potential class action liability in the hundreds of millions of dollars, disclosures aren't just a technicality anymore. They're really a necessity. So if you're creating content or working with influencers, take the time to understand and implement proper disclosure practices. The few seconds it takes to add ad or sponsored to your post could save you a world of trouble down the road. Thanks for watching. If you learned anything from this, please like and consider subscribing. I'm going to continue to post videos about issues like this and other things that have to do with the legal side of e-commerce and digital marketing. And if you have any questions, drop them in the comments below and I'll try to respond to the ones that I can. Thanks.